Can you keep a secret? Well, in this video, I'm going to quickly talk about a case called Waymo LLC versus Uber. This is a 2017 case from Northern California District Courts and Court of Appeal about secrets. So Google's sibling company called Waymo LLC is a company that developed self-driving vehicle technology. And one of its employees was named Anthony Levandowski. Call him Anthony. So Anthony left employment with Waymo and built another company called Automodo. And Uber came along and purchases Automodo. And so Waymo sues Uber, Automodo, Anthony for patent violation and infringement of trade secrets. They allege that when Anthony left employment, he downloaded thousands of files containing patents and trade secrets about self-driving vehicle technology. Okay, so there's this lawsuit. And Uber's lawyer slips a piece of paper to Automodo's lawyer and says, our interests do not align with Anthony's interests. Not of agreement. That is called client-lawyer privilege in common. It's kind of a brief moment where lawyers can kind of confer and be like, okay. So Automodo's lawyer and Uber's lawyer get together and develop a secret agreement, obviously without Anthony. And they have this secret between themselves now, right? And they agree to hire a company called Stroz Frieden LLC. Stroz, you can imagine, these are like tough, like investigators, police people, lawyers who are like pretty hardcore, to investigate the risk that Anthony might have taken these trade secrets, which is obviously, well, maybe improper, right? So, but they say, look, we will buy Automodo pending this investigation. Okay, so this is they're hiring Stroz as kind of like their lawyer people who are going to do this investigation, right? So obviously you can imagine Anthony was not happy about this investigation. It was extremely hostile. And but they kind of calm him down and say, look, Uber will indemnify you, Anthony. We'll indemnify you. We'll take all the financial risk of this whole situation from you. We will sign an NDA, right? This will be completely secret between us, but you have to tell us the truth of like what you have, right? And so Anthony's like, okay, like $240 million, right? So back at the courthouse, magistrate's like, oh, in the matter of Wyatt LLC and Uber et al. All right, folks, hand over the disclosure. This is the lawsuit, people. Get going. So hand over the documents, and Wyatt's lawyer says, excuse me, where's the Stroz report? We heard that Stroz Friedenborough LLC was doing an investigation into Uber about Wyatt employees coming over and taking trade secrets. So where's the report? And the magistrate's like, well, it sounds like it's relevant and material. That's for sure. Where's the report? And so Uber's lawyer and Automotive's lawyer are like, absolutely not, Your Honor. No way are we handing that report over. That is protected by lawyer-client privilege. And the magistrate's like, well, what about you, Anthony? Anthony says, well, I'm with them. Yeah. Lawyer-client privilege, in common. And the judge is like, no. Do you have any relevant material documentation? You're going to hand it over. And And he's like, no, Your Honor, I'm not going to do that. He's like, excuse me? What did you say to me? And he's like, I'm not going to hand it over. No, I'm not going to. And so the magistrate's like, well, what's your legal authority for that? And so Anthony says, somebody get me a piece of paper. I need a piece of paper over here. Lawyer-client privilege in common. That's my authority, Your Honor. And the judge takes it. He's like, okay, well, I see you have a writ of mandamus. No, I refuse. Hand it over. So this goes to district court. You need to go to a bigger courtroom for this kind of thing. And so here we have Anthony ranting in the background. He probably wasn't like that in real life. I mean, it's more complicated, right? With like, Strauss, you can imagine these guys are like police people. There's probably accusations of theft of $240 million. Like, this is serious stuff. But he's kind of acting like, does this federal district court even know what a trade secret is? I mean, should I be accusing myself of committing crimes over here or something? I do declare I have a Fifth Amendment right not to self-incriminate. Your Honor, I have a writ of mandamus. Wrote it myself. Our lawyers, we have a freestanding right of lawyer-client privilege. So the judge kind of talks to the lawyers a little bit. Is like, okay, I see there are some elements here of lawyer-client privilege, which is obviously beyond my jurisdiction. But Anthony does not have a right to refuse a magistrate's orders. He's not entitled to lawyer-client privilege. Self-incrimination, I say. To be entitled to a writ of mandamus, first he must have no other means to get the relief he requires or desires. Like there's other courts, for example. Here we have the districts, the Court of Appeal. You can file interlocutory appeal. And next he requires clear and indisputable proof of such a right. And finally, we'll only grant the writ of mandamus if we want. Sir, Anthony says, if I follow the magistrate's order and reveal the material, it would be an inadequate remedy. I don't agree with you on that, Anthony. Well, the writ is certainly not appropriate. I order disclosure. No, sir, I appeal. Courts do not have the right to force litigants to unlearn what they have learned if the information has been tainted by a breach of client-lawyer privilege. So at the Court of Appeal. Now, okay, so the senior judges come in now. They're like, okay, right. To hear this appeal, first we must determine, that there's absolutely nothing else to be determined other than that the judges were completely wrong. They made a clear and indisputable error, and our jurisdiction covers final decisions of district courts of the United States in any civil action under any act of Congress related to patents, authority over admiralty. And does anybody have any objections to our hearing this appeal, or thinks that our decision is not final? And the lawyers are like, oh no, Your Honor, of course your decision is final. And Anthony's kind of like, oh, that's not my understanding, all right, so then the judge says to Anthony, okay, Anthony, nobody is questioning your Fifth Amendment right not to incriminate yourself. That's a personal privilege you have. But here we're just a civil court. We're just disclosing everything material and relevant, like documents. If you have any documents in your possession that you have not destroyed, and to have client privilege, people retain a lawyer. So you hire a lawyer, in confidence, and you get some legal advice. So everything that you got legal advice, that's privileged. It's confidential. And then Anthony says, well, There is not a single piece of information on the record that contradicts that I have not waived my common interest privilege to lawyer-client secrecy. And the judge says, well, I disagree with you because I have the Strauss report right here. And in it, Uber and Automoto have included information about a piece of paper that they say their interests don't align with yours. And you failed to challenge extensive findings here on appeal that your communication with Strauss were certainly not privileged. Automoto's lawyer is not your lawyer. Uber's lawyer is not your lawyer. And you're not part of a common interest group. You failed. Why do you think that anything is privileged? And so Anthony says, well, Your Honor, there was this NDA. Like, I can't. There was an indemnification, and they were purchasing my company. And the judge said, well, then, fortunately for you, you were very honest in your answers to Strauss, so you are properly indemnified. I see this could be much worse for you if you were not honest and told them everything. So, costs go to Wyatt for having to ask if someone might have taken trade secrets.